Did you? All right, good morning. We're going to run through the clerk has a docket of motions to dismiss in cases that have been pending without any activity for some time. So I'm going to run through and call those, and then we'll start with the regular docket. Most of these are probate. This would be the estate of Sarah Joyce Berry. Anyone here on the estate of Sarah Joyce Berry? Dismiss, failure to prosecute. Estate of Vera Ellen Blythe. Vera Ellen Blythe.
We had thought that had been closed some time ago. Our interest in that was that we had opened the estate. Along the lines, there was a dispute between two of the beneficiaries. The court had decided at one point that would be kind of bifurcated interest in administrating that. We handled the real property, which we did all those things, close it out. That left a secondary administrator for personal property. We've not heard a thing from them. From our standpoint, it's fine to close that out. Have not heard from the secondary person at all in that period of time.
So at this stage, what do we need to do to finalize the estate?
Well, it would be getting it again, from our standpoint, we are finished. We did all the things that we were supposed to do. It would be that secondary person that was nominated as the administrator to that portion of the estate. We don't know of anything that there's there. I can file something with the court stating that purpose and close it. From our end.
File something that shows what your participation in the case representative, whether it's been concluded, and then that whatever the remaining portion is would need to be dealt with by the secondary person, and then we'll put it on another show cause docket for that individual.
That'll be just fine. And was there a companion? I think that one. This role in this case, I believe, is also when they're not getting that companion that comes to us. They're both being the same.
That would be Juanita Fern Butler Walden.
That's correct.
So we need to do the same thing in that. Is that correct? All right. Show that will be put on a subsequent show cause docket after Mr. Hamlin has filed a statement showing what his participation has been concluded, that his participation has been concluded. The estate of Vicky Ramona Williams Ford. Dismiss, failure to prosecute. Estate of Melvin E. Henley.
Well, we have everything in order to close that. We said.
Do you have another date for show cause? Just give them about 60 days down the road. Where are you going to be in 60 days? I need you to come back and handle the show cause document. That's fine. That'll be 4 months down the road, so put it in November. That's fine. November the 3rd. All right. We'll look for you then, Ms. Jenkins. All right, November the 3rd at 10:30 a.m. The estate of Daisy E. Watts. Dismiss, failure to prosecute. The estate of James Edwin Barnes. Anyone here on James Edwin Barnes? Dismiss, failure to prosecute. The estate of Lula Mae Bryant. Dismiss, failure to prosecute. The estate of Anthony Ray Carney. Dismiss, failure to prosecute. The estate of Andrew C. Wilson. Dismiss, failure to prosecute. The conservatorship of Glenn Cecil Watts. Do we have a conservator on that? That's a little different than this one. That one is. Mr. McNabb was here. Mr. McNabb do you represent the moving party in the Glenn Cecil Watts conservatorship, Mr. McNabb? It is here today on a show cause docket for lack of activity. My only concern is if, rather than dismiss a conservatorship that's pending, I need to know what the status is, if the individual is still under a conservatorship, what's been done. They've passed away, and it needs to have an order concluding it, and any assets need to be transferred to a probate matter. We'll put it on November the 3rd, Mr. McNabb, if you'll take care of getting that concluded, please. And is the Glenn Cecil Watts, is that the estate of Glenn Cecil Watts? All right, put that also, both of those will be moved to November the 3rd to try to conclude them. Betty Jean Copeland estate. Betty Jean Copeland, here to prosecute, dismissed. And lastly, the estate of Joanna Hyde. Anyone here on the estate of Joanna Hyde?
Response to this, I was appointed as a guardian, but never, if you look at the original order, there's no certificate of service. And then the other orders were sent to my address that I haven't been at in years.
Well, the problem is you were appointed a guardian. I reviewed that file, and you were appointed the guardian ad litem, but you were never made aware of the fact that you were the guardian ad litem. The child was at that time 12 or 13 years of age in 2016 or 17. And now she has attained the age of 20 some odd years of age. So clearly, there's no need for, and a Judge Lockhart Mash, I believe it was, signed off on the sale of the real property without your input. And as a result of that, it seems to me that there's really nothing for you to do and no participation. If you want to file something in the record that shows that you were never made aware of your appointment and had no participation, so that there is, I think you've actually done that, and we'll let that stand on its merits. But the fact is that today the young lady is asking for her portion of those funds that were being held to be paid to her, since she has now attained the age of majority. So since she is an adult. And
I'm fine. I just wanted to make sure the court knew that I wasn't derelict on my duties, but I never received here, but I never received the orders.
Understand.
Except for the motion to dismiss.
Well, I think that the address that was utilized for sending you the copies of the orders was not your current address or your proper address. And the only notice, if I understood correctly, is that you received was from the clerk, which was sent to your correct address.
Yes, sir.
Now, in this particular case, that doesn't present a problem because the young lady is now an adult and there's no need for a conservator at this point. And apparently it's been handled by a different judge without your input. But in the future, clearly that could become a problem. If there was another case such as this, I will go ahead and handle this. This in the estate of Joanna Hyde. Mr. McNabb, that's your motion to close the estate. Pardon?
Child was emancipated and ordered her money, so
Is she here?
with her bit of an order to the court.
Yeah, and you have submitted an order to the clerk, and it basically is saying that you close out the estate. But the money has not been paid over to the young lady at this point. Is that correct? It has. Was that what Judge Judge Turnbow signed? Okay. Judge Turnbow signed earlier in the month of June an order apparently to. All right, I will sign the order closing out the estate then.
Thank you, Your Honor.
Thank you. All right, we'll now move to the regular call of the docket. Madam Clerk, you want to call the first case? Well, we have a matter of Woods versus Woods that's going to require argument and possibly a hearing. I'm going to run through the first page of the docket, which are usually short motions that we can take care of as many people as we can, and then we'll start it. The Woods case will be our first contested matter. We have Mr. Gillett is in Michael Gillett is in the Zoom room. We bring in Mr. Gillett and ask him to turn on his. Mr. Gillett, if you can hear me, I need you to turn on. There you are.
Yeah, sorry, sir.
You are here today to testify regarding the opening of an estate for Rhonda Jean Gillett. So I need you to raise your right hand and let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You are here on the screen with us, and your lawyer is here in the courtroom, so I'm going to let her take it over from here.
Thank you, Your Honor. State your name for the court, please.
Michael Gillette.
Mr. Gillette, you were married to Rhonda Jean Gillette in back in 2024 when she passed away. Is that correct?
That is correct.
And did she pass away in Cheatham County
Yes, she did.
at the age of 72?
I believe so, yes.
Okay. And did she leave a will?
No, there was no will.
And do you know if she has 3 sons from her previous marriage, is that correct?
Yes, that is correct.
And they have all been notified and they've all consented to you serving without bond? And have they waived inventory and accountings?
Yes, they have done that.
And are you asking the court to open an estate for Rhonda Jean Gillette so that you could administer the assets and make sure that all the debts are paid?
That's correct.
Those are my
All right.
questions, Your Honor.
Thank you. I found that there is everything's in order, and I have signed your order to issue letters of administration to Mr. Gillett, and that estate will be open. Thank you.
Thank you, Your Honor.
Thank you, Mr. Gillett. You can leave our hearing now, so.
Thank you.
Call the next case.
I'm gonna put you under oath.
I'm going to ask you to raise your right hand and be placed under oath.
Ms. Patterson, please state your full name for the court.
Bill W. Patterson.
And how were you related to Randall Luther Patterson?
He was my husband.
And at the time of his death, he was a resident of Cheatham County, correct?
Correct.
And did he have a will that you were able to find?
No,
Were there any children?
no,
So you are his sole heir and beneficiary, correct?
that's correct.
Are you asking the court to appoint you as the administrator of his estate?
Yes,
And you understand you've got to abide by the laws of Tennessee and that we'll publish it for creditors as well? Okay, and you're asking that the court grant your order today, is that correct?
yes.
All right, I'll grant your petition to open the estate and appoint her as the administrator. I'm sorry for your loss. All right. Call the next case.
Mary Simmons estate.
Well, if you'll raise your right hand, let's place you on the oath.
Yes, ma'am.
Please state your full name for the court.
My full name is James William Pardue.
And you are asking to be appointed as executor of the estate of Miss Simmons?
Yes, ma'am.
And how are you related?
I am her grandson.
And were you appointed under the will?
Yes, ma'am.
And you submitted the original will to the court, correct, through my office?
Yes, ma'am.
Okay, now, we have received waivers from some family members, but others we have not received back. Is that correct? Do you understand that as the executor of the state, you will be ordered to abide by the laws of the state of Tennessee?
Mhm.
And we will publish a notice to creditors in the newspaper, and you will not distribute assets until the estate is ready to close.
Yes, ma'am.
And you'll gather those assets in account form. Is that correct?
Yes, ma'am.
And go by the will and distribution.
All right, everything's in order. I will admit the will to probate and appoint him as the executor pursuant to the provision of the will.
Thank you, Your Honor.
Your Honor, this is a motion for default on a TPR that was filed. You can see that the parents were served in April and should have had their response by now. And they're not present, and so I would ask just have a default entered against them, and then we'll set this for a final hearing.
All right, then I will grant your, well, let me follow up and make sure. Brittany Crowder, Sean Snell II. Neither of them have filed an answer or appeared in response to summons, and therefore your motion for default is granted. You want to set this then for a hearing?
Yes, Your Honor.
How long do you need to,
It'll be 10 minutes or less, and I
I
can
mean, how far away?
oh, just as soon as the court wants to hear
Do
testimony.
it today if you want to, but if
I
you
think that they might want to have the child present, and so we didn't really plan for
think
that
that
because we
would be
didn't know.
appropriate, you can do it tomorrow morning. You want to do it tomorrow morning, or we can do it later in the month, whatever you want to do.
All right, let me make sure that I can see what I've got going on real quick. Thank you, Your Honor. We weren't expecting that. Yeah, I mean, I can come in the morning if you want to do that. All right.
I'm not trying to rush it through, but I mean, I'm here tomorrow morning, and then I don't have Chancery again until the 14th of July. And I have the 15th of July
All right, we'll see you in the morning.
tomorrow morning,
All right, thank you, Your Honor.
9 o'clock. We'll see you then. Tomorrow at 9.
Chris and Sally Jenkins versus Amanda Sewell and Alan Bradford.
Your Honor, this is a similar situation, except there's, I still have to do publication on one parent. So I'm just asking today for a default against the mother, Amanda Sewell.
Amanda Sewell. Sewell was served with process and has failed to file an answer within the allotted time. The answer was due April the 25th. No answer has been filed. Your motion for default as to that defendant will be granted. We'll reset the matter until after you've served the putative father by publication.
Thank you, Your Honor.
Yes, I granted the default, and we basically pass it on the docket because they've got to serve the father by publication.
Elizabeth Jenkins versus Brian Eels. Might not be here because she.
Oh, I think Ms. Wilkerson has. All right, the motion for default is stricken based on the answer being filed.
Derek Anderson versus Michelle Wallace.
This is a post-judgment interrogatory motion to compel. My client received a judgment against the father of her children, and he has not responded to the interrogatories that were set. So we're asking the court.
Why are you sending interrogatories to someone when the case is concluded?
Because she received a judgment pursuant to the final order.
So these are collection interrogatories, all right?
So I would ask the court to enter an order to give him 30 days to respond, or that the court would issue a show cause.
But he'll put an order down that serves on him that shows he has 30 days to fully answer the interrogatories that were sent to him. And then we'll just see whether or not that is complied with.
Thank you.
Doris Pratt, you.
Your Honor, this is our name change petition. Mr. Kraft has always been known by a name other than what's on his birth certificate, and he wants his birth certificate to match what he's known by in the community.
Rowdy Wayne Craft.
Yes, Your Honor.
So Rowdy was what everybody knows you as.
Everybody's called me that, my parents, since I was young, so.
But let's raise your right hand. I've got to have you placed under oath.
I do.
I continually show my age by referencing movies and TV shows that most people are too old to remember. That you, if it was Rawhide, do you remember the
Yes.
TV show Rawhide?
Yeah.
There was Clint Eastwood's first major role was Rowdy Gaines on that show.
Yeah.
I'll never forget it. Anyway, so I wonder if that's where you got that nickname. So you look a little like Clint. You're not as tall as Clint, but you do.
I
look
wished I
like
was as
him.
tall as Clint.
I wish we had his bank account.
Yeah.
Ms. Brady, you may go ahead and put on your proof.
Sure. So, Mr. Kraft, you filed a petition for a name change, asking your name to be changed from Doris Wayne Kraft Jr. to Rowdy Wayne Kraft. Is that right?
That's right.
And you're not doing this to evade the law. You're not doing this to evade creditors. There's no nefarious purpose, just
Right.
because you want it to match what you've been known by in the community.
Yes.
That's all I have, Your Honor.
All right, Rowdy, we're going to change your name to reflect who you really are. So
All right. Thank you. What do I need to do now? Okay. All right, thanks.
pretty cool nickname. So
If you fail. My client told me she's running late, but she doesn't have to say she's parking.
all right, we'll come back to it.
Mr. Glover.
Good morning. You'll raise your right hand. Let me have you placed under oath, please.
I do.
You are Kristen Lee Glover, is that correct?
Yes, sir.
Ms. Glover, you have filed a petition to change your name, and I'm required to ask you some mandatory questions. Are you asking to change your name to avoid your just debts or creditors?
No, sir.
Are you asking to change your name to avoid criminal prosecution?
No, sir.
It's my understanding you're just asking to change your last name to Blevins.
Yes, sir.
All right. And I will ask you to sign off. I've drawn a line there for you to sign off on that to approve that. You'll sign off on that. You can use your new name.
Use my new name?
Yes.
Been a while since I've signed that one.
All right, Ms. Blevins, I have changed your name, and you may get a copy of this a little later in the morning when it's transmitted to downstairs, okay?
Okay. Thank you, sir.
Thank you.
If you fail.
Well, if you got your breath, you caught your breath yet?
You heard me struggling back there.
Raise your right hand, let's place you under oath. We're gonna go ahead and take you up because I don't think you want to get behind everything I've got left on the docket, so.
Yeah.
No, that's good.
State your full name for the court.
Tiffany Rochelle Field.
Okay, now you just learned that your name was changed after the separation of your mother from your stepfather. Is that correct?
Correct.
And it was changed in another state. Is that correct?
Correct.
And when you received a copy of your birth certificate, you found that your name of Tiffany Rochelle Bridges was changed to Tiffany Rochelle Field. Is that correct?
Correct.
And that was trying to get the star ID and all of that, correct?
Yes.
And so you're asking that, but your driver's license and all your school records and everything are under Bridges. Is that correct?
Correct.
Okay. Are you asking that your name be changed to reflect on your birth certificate, your given name of Tiffany Rochelle Bridges?
Correct.
You're not doing it to avoid creditors,
No.
not avoiding criminal prosecution.
All right. I'll be happy to change your name. You have an order? Hopefully something will stick, so.
The star ID may find a lot of misdone names.
Yeah, I have those, all of my kids are Bridges, like my credit is in Bridges, everything.
Thank you.
Thank you. All right, we're next moving to the second page of the document, which are more contested. We have Tara Bailey versus David Bailey. Anybody here on that case? I'm showing it was set for 3 hours on November the 5th, correct? Let me run through the rest of these and find out before I started on the Woods case. Charles Moore versus Richard Chappell, Mr. Manis and Mr. Shoemate. Come on up. It's a fairly straightforward motion to dismiss based on the fact that they failed to substitute an individual for the deceased plaintiff in the case. Is that correct?
That's correct.
Have you heard from Mr. Manis? I understand Mr. Moore is deceased.
We spoke to Mr. Manis, and our understanding is that right before his death, Mr. Moore hired a different attorney, Mr. Albritton, but Mr. Manis is still attorney of record in this case. We've spoken to both of them. Mr. Manis feels that he doesn't have a client, so that he can't say that he doesn't oppose or oppose the motion. Mr. Albritton has been hired by the family and does not intend to oppose the motion.
Well, I think it's pretty straightforward that if they have not substituted a party for the deceased individual after notice of death is being given pursuant to statute, then I shall dismiss the action. It's not discretionary, it's a mandatory, so I will grant your motion to dismiss.
Thank you, Your Honor. I have an order if you would like.
Thank you. You can draw an order, please.
I have one if you
You
would
have
like.
one? All right. You will hand that to the bailiff. All right. Thank you. Sign you.
Thank you.
All right, the next case on the docket is William Romkey versus Sarah Baker. I'm just trying to get a time estimate. Do we know about how long it will take?
No. Meetings on this. I would say probably 15 to, yes, I'm shooting with that.
Okay. I have a case from yesterday I rolled over to this morning, so we're going to take it up first. But all right, and then I have Franco Lewis versus Dion Lewis.
He's with the administrative office for the courts in Nashville, and I just get to testify with.
Is that Doug Strickler?
Yes, it is.
So are you saying that there is a time constraint?
That they're packing through the process, easy process. And so I need him to testify. That's my understanding of what they're arguing.
We are protecting the service process. Our after service process is that the actual warrant wasn't served, that when she was served, she was, once a process certificate to the house, he gave her a marital dissolution agreement and a parenting plan rather than a amended complaint of divorce.
All right. Well, let's, since you have someone on Zoom that's waiting and you say this person works where?
His office is a first voting judge and, but he's overseen.
Well, let me take this case up since there's some urgency regarding this witness, and then we'll come back to the rest of the case. Following this, I will take up the Woods case from yesterday. So, all right. So we're going to take up Franco Lewis versus Dion Lewis.
You want to take the defendant, the opposing counsel's witness out of order so we can get that done.
That would be fine with me if that's suits you all. Whose witness? Is it your witness, Ms. Tech? Is this individual your witness, Mr. Strickler?
Yes.
Okay.
Yeah.
All right, I'm going to admit Mr. Strickler in and then let you put him on first, and then we'll take him out of order so that he can go on about his business.
Okay.
No, it's just there.
Yeah, right there, yeah. Okay.
If I may, Your Honor, this is the case, ma'am.
Mr. Strickler, if you can hear me, I'm going to ask you to turn on your camera and unmute your device.
Yes, sir.
All right, thank you. We can see you now, Mr. Strickler. I believe we can hear you. So if you're able to see and hear us, okay?
I can hear you, Your Honor.
All right. I'm going to ask you to raise your right hand and let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Ms. Tech has called you as a witness in this proceeding. So Ms. Tech, if you'll pull that microphone down just a little bit.
Okay.
So make sure that he can speak directly into it because our sound system's not the greatest. We need to make sure he can hear everything.
Okay. Mr. Strickler, can you state your name for the court and in what capacity do you work for Davidson County?
Douglas Strickler. I'm the Director of Security for the state trial courts.
Okay. And how long have you had that job?
I've been with the state trial courts for 24 years. I've been the director for 4 years.
All right. And do you on occasion help out with service of process?
Yes, ma'am.
Okay. And do you sometimes work for a company called Southern Process Service?
I do.
Okay. And what can you tell us about that company, sir?
It's owned by Kevin Williams. I've served subpoenas and summons for him for 7, 8 years. And as far as I know, it's been a really good company.
How long have you served process for Southern Process Service?
About 7 or 8 years.
Okay. And do you understand why you are here today? They're saying that you did not serve Mrs. Lewis. Can you tell the court if you remember how you got the paperwork and what steps you took to serve her?
I do remember serving her. I don't remember if Kevin, the owner, brought me the paperwork. That's the way it normally goes. He brings me the summons and subpoenas and warrants, and I look up the addresses, and then I go out and I make my attempts. And when I was notified of this, I have a pretty good memory. Once I am somewhere once, I always remember. And I looked up the address and the name, and I remember it was early on a Saturday morning. It was a rainy morning. And I remember serving this woman. I remember her coming to the door, and I think maybe kids were there also, but I remember the name and the address, and I remember her answering the door, and I remember serving her.
Okay, sir, can you see in the courtroom, is this the young lady that you served?
You may not be able to see very much. The camera system
I-
is not.
I can't see it, I'm sorry.
Well, I think that's important. Can she stand somewhere where you can?
All right, Ms. Lewis, if you will stand and come to the podium, please. We need to, can we close those blinds back there? They be effective. No, the ones right on the back wall, I think, are the ones that are, yeah. Can you reach that? If you can't, that's fine. So, all right, let's see. Can you see her now?
I can see the back of her head, Your Honor.
Okay.
Could you take a step back?
If she could just turn around,
Have her come on up here. Just step right up here. Step right up here, please. This camera will pick you up a little better. So, yes, you're fine.
Okay. Mr. Strickland, was she the young lady that you served? I know it was 3 years ago, but is she the young lady you served?
if you don't mind me saying, Your Honor, the camera I'm looking at is from the back of the courtroom. If the young lady could turn around and face the back of the courtroom, I'd be able to see her face. There you go. As far as I remember, it's been 3 years, but that she looks like that was the woman that I served.
Okay, now, are you familiar with court pleadings?
Ms. Lewis, you can have a seat.
Okay. Are you familiar with what summons looks like and what a complaint for divorce looks like, sir?
I am.
Okay. Did you have a chance to look at the paperwork before you served it on her?
Just the cover page. I really don't recall whether it was what it was. I don't read them. I just look at the name, the address, and then where I do my return of service. And
Did you understand? I'm sorry.
No, that's all right. I don't normally read what they are unless I have to. I'm just more concerned of getting the individual and getting it served
But
on
you
them.
recognize, okay, but you recognized it as a summons that you were serving on her?
Yes,
Okay. And she, in fact, did you have her sign the summons? That is her name that appears on the summons?
yes, ma'am.
Okay. And attached to the summons, was it did it say it was out of Cheatham County?
As far as I recall, yes, ma'am.
And also attached to the summons, was it a complaint for divorce?
I'll be honest, I don't remember exactly what it said on it.
Okay, well, would normally marital dissolution agreements be attached to a
Objection.
summons?
He's already testified that he didn't know what was attached to the summons.
The objection is to, hold on, Mr. Strickland, I have an objection to deal with. Your objection is to the fact that the question is asked and answered.
The question is asked and answered, and also the question is asking for his opinion as to what would come normally with the service, and he's a service processor. Why he does do that, that is not with what normally comes with the service of process, is not, his opinion of that is not relevant.
Ms. Tech, do you want to respond?
Well, I'm asking him in his normal course of business, would what normally is attached to a summons is a complaint or petition. And
Well,
maybe
there
I
can be all
shouldn't have
sorts of
rephrased it.
things that can be served by process. I sustain the objection because I think he's already indicated that he doesn't recall specifically what was attached. The return on the service of summons that was signed by him states that it was a copy of the summons and complaint was served on her, but his memory as far as what that was, whether he remembers specifically that there was a copy of the complaint, you know, he's indicated he doesn't recall, so.
Okay.
So I sustain the objection.
Have you ever been accused of serving bad process?
No, ma'am.
Okay. And was that in fact her signature, Mrs. Lewis's signature on the summons?
Yes, ma'am.
What do you normally tell people when you serve them? For instance, what did you say to her when you had approached her?
I would have explained that if this has been a summons of divorce, I would have looked on the front page, saw when the court date was, or if it was, she had 30 days to respond with her attorney, depending on what it is. I give them the court date, where they need to be. I point out the attorney's name and number, and I don't answer specifics other than the court date, the time, the place, the attorney, phone number. I have them sign, and I leave that with them, and that's it.
Okay. Did at any time after that date that she was served, did she attempt to contact you again?
No, ma'am. No one has contacted me other than you.
Okay.
And then years later.
Okay. I don't have any other questions.
Von Berger?
Yes. The day you served these documents, were these documents in a folder? Or, excuse me, in an envelope?
No, they were not.
Okay, how do you know that they were not in an envelope?
I don't normally serve things in envelopes. I don't recall this being in an envelope. I normally have a stack of summons or whatever. And like when I go to Montgomery County, I probably had 15 to 20 to do that morning. And that would have been, I set a route for myself, and that would have just been the papers right there. And I would have just brought the papers and taken off the top, which would have been the return of service for me, for the clerk's office, and given her whatever I had stapled or paper clipped together that would have been her papers. So I don't recall anything in an envelope.
So you don't specifically, you normally serve 20, how many did you say in a day? 20 to 50?
Oh, no, 15 to 20 on a Saturday morning.
15 to 20.
Yes.
And in this particular instance, you don't recall what the exact paperwork was?
I just recall it being the summons, and I remember serving it, and I remember her coming to the door. I don't remember exactly what it was, to be honest, until.
Okay. And have you in the past have you served envelopes before?
I don't normally serve envelopes. That's not the way they come to me. They come to me in a big folder, a stack of summons or civil warrants or subpoenas, and they come to me in a folder, and I take them all out. I look up each one on MapQuest. I print out a map, print out my directions, make notes to myself, and then I go and find the people and I serve them. I don't serve things in an envelope.
That is the way that you say they typically come to you. But
That's
in
correct.
this case, you do not recall, correct?
I do not recall it being in an envelope.
Okay. Nothing.
Let me ask this question. I have the file before me and that return of service of summons is a part of the court record. And it states that on the 16th day of April, 2022, it states that I served the summons together with the complaint herein as follows. And then there's handwritten in by personal service on the defendant, Ms. Lewis, served copy of summons and complaint at 915 Nectar Court, Adams, Tennessee. Would you have written that you served a complaint and summons on her if you did not look at it or knew what you were serving? Or is that just the standard way you?
That's standard return for a chancery, and depending on the attorney in the chancery court, that's standard verbiage for that.
So it doesn't indicate, the fact that that's written in doesn't indicate that's what you saw when you were serving her.
That would have been part of the packet, Your Honor, and I did not, like I said, I did not open the whole thing up or read. I don't read the whole thing. I just knew that there was more than just a cover, just a one page. I knew that there was a
Well, I guess
complaint.
that's what, I have to make this decision, so that's why I'm asking these questions.
Yes, sir.
The fact that you wrote that you served a copy of the summons and complaint does not necessarily mean that's what was actually given to her because you didn't open it and read it. Is that what I'm understanding?
Yes, sir. I knew there was a copy. I knew that that was all in there. I just don't open it up and read it. And I know
Open
that
what?
in
If
a
it-
divorce.
If it
I'm
was
sorry.
if it wasn't in an envelope, what did you have to open up and read?
Well, it would have been the papers would have all been stapled together or paper clipped together. There would have been a thicker packet. A complaint for divorce is normally thicker when I get those, and I know that part of a divorce there's always a complaint and discovery, and then a lot of times there's the questions they have to answer. So,
All right, thank you.
Interrogatories.
Anybody have any questions for Mr. Strickler after what I've asked?
No.
Thank you, Mr. Strickler. You may leave our hearing.
Yes, sir. Thank you.
All right. Mr. Bonenberger, this is your motion. If you want to then put on any other proof you wish to put on.
Yes, sure, I do. I would like to call my client, Diane Jaggelson Lewis.
She'll need to come around to the witness stand. Ma'am, if you will come to the witness stand and raise your right hand and face our clerk to be placed under oath. Raise your right hand, stand up, please. Raise your right hand to be placed under oath. Ma'am, I'm going to ask you to speak directly into that microphone, okay?
Okay.
All right, thank you.
Can you please state your name for the court?
Dion Jaggelson.
Ms. Jacobson, you and your husband split in when?
We separated the night of July 31st, 2020.
Okay, and originally y'all were working together on a parenting plan.
Yeah, are we investigating the divorce? I mean, this is a very narrow Rule 60 motion. And I'm assuming they're trying to prove some kind of an error here. And if that's the case, then I am a witness because I know exactly what I did and what I gave Southern Process Service and what I gave Mr. Strickler. So, I mean, I just find this.
There are several.
Well, first of all, what's the legal basis of the objection?
That Rule 60 has to be very narrow. Now we construed, it doesn't matter what happened. We're talking about service of process. They have a document that is an MDA that was in fact mailed to her that she has handwritten, received April the 22nd and that is not the document that I mailed, that was served on her. I think.
All right, I'm going to interpret Ms. Heck's argument to say that she's objecting as this information is not relevant to the proceeding before the court. Mr. Bonenberger?
Your Honor, there's a couple things that are relevant before the court. First of all, the main issue is whether or not she got notice, and it is included in the initial Rule 60 motion, which was filed by previous counsel, that whether or not she actually got good notice of the amended complaint. Secondly, whether she got notice of the motion for default. And the third problem comes with the fact that these parties had signed agreements, including a quitclaim deed that was signed 2 years prior to this divorce agreement by the husband, quitclaiming the marital property to the wife when they got separated,
10 days.
and was filed with.
Can he prove under Rule 60 that there was an honest mistake, you're done? And if that is.
He's making an argument and then responding to your argument about why this material is relevant, Ms. Heck. If you'll let him finish, then I'll consider whether or not it is or is not relevant.
The marital dissolution agreement divides the marital property and puts a sale date on the marital property, saying that they will continue to own it as tenants in common, and makes it tenants in common when the husband had quitclaimed that deed to the wife over 2 years before and they didn't own it in tenants as common. And in addition, the agreements they made as to child support and alimony were not included in the final decree. And nowhere in the final decree does it say anything about the husband's significant retirement that was not divided in the final decree at all.
What you're asking right now
is to set aside
I know that, but I mean, what you're asking, the questions you're asking that Ms. Tech objected to had to do with these negotiations that had been going on during the previous to the entry of the final decree, correct? Ms. Tech's argument is that a Rule 60 motion is very limited to one of the bases that's set forth in the motion, either mistake, inadvertence, or excusable neglect, or the second basis is fraud. And both of those must be brought within 1 year. And then it goes on to talk about other basis. And the final one is for any other justifiable reason that the court finds would be required to set it aside. So my question to you is, how does what you're asking this witness testify about relate to any of those bases for a Rule 60 motion?
Fraud in that he represented, he had an interest in the house that he then had the court divide. Fraud in that he never brought up the signed agreements and contracts that were between the parties.
If you will let him finish, I'm going to give you an opportunity to respond.
We can provide notarized copies of the agreements between the parties that were never addressed in the filing or in the
We understand that an agreement between the parties during a pending case may be considered to be temporary in nature or even negotiations in nature, and that it's not a binding agreement unless it's signed off on by the court. You understand that?
I understand that, Your Honor. But it should have been, there should have been a motion to set that agreement aside as it was a contract between the parties. The court definitely has a duty, the ability to set those agreements aside because they are temporary in nature. But I believe that those contracts can be enforced as part of the marital dissolution agreement and have been upheld by courts. However, the fact that those agreements were not brought up and mentioned in the final degree in divorce and set aside indicates to me that they were not ruled on by Your Honor. And the fact that they were not brought up and ruled on by Your Honor is the basis for a Rule 70 motion. It also goes to my client's belief that she was still negotiating her divorce. The way she found out that she was divorced, the testimony will show, is when she received the bill of costs and called the court to ask why this bill is. In her interaction after she received that and called her now ex-husband, I think believes that there was, at least on the ex-husband's part, an attempt to deceive her about what is going on.
All right, Ms. Tech, I will now hear from you regarding this. Mr. Bonneberg, if you'll step aside and let her have the microphone, please.
First of all, I think he admitted that she knew a divorce was pending, okay?
No.
Ma'am, you need to be quiet.
Then you called my office several times.
Talk to her, talk to me.
Okay, I called her several times. I talked to the office again. I don't want to be a witness in this, but if I have to, I will. We talked extensively. I said, you need to get a lawyer. You need to get a lawyer. She knew that the divorce was pending. We've had several conversations about it and about what was going on. And I just, for her now to play dumb about this whole thing is ridiculous. That didn't happen. She got served with a complaint. I know what a complaint is. I've been doing this, as I said, for 32 years. I do this all the time, Judge, and this is the first time someone is saying that I put a marital dissolution agreement to serve. I know that's not how it's done. I didn't do that. She got the complaint and she said on the phone to me several times, what does this mean? What do I have to do? Well,
that makes you a witness in this case.
Yes, it does now.
Therefore, I'm going to stay these proceedings. Ms. Tech, you're a lawyer. You cannot be a lawyer and a witness in the same proceedings.
Didn't think it would be this way.
And as a result of that, this matter is going to have to be stayed, and we're going to have to allow your client to obtain another counsel to represent him in this matter. We can reset this for later in the month to come back to, since I've already heard from one witness.
Okay.
That would be the most appropriate way of handling it. What about the 29th day of July?
I think that would be fine.
Mr. Bonneberg, Ms. Lewis, step down, please.
I have a final hearing at 9 in Montgomery County that should not take long, but it's one I can't move.
Again, a Rule 16 motion, I don't see how that is proven. There's no fraud here. There's fraud.
Well, let me make sure that we understand. Court has an obligation under the statute to, when I approve a marital dissolution agreement or I approve a final decree of divorce, even on a default basis, to ensure that there is an equitable division of the property. Mr. Bonneberger has raised some issues that indicate that there is some question about whether or not that was or was not properly presented to the court. I'm not saying that that's true, but I'm saying that's an issue that's now been raised that makes potentially the court requires this court to examine more of the detail of the case in order to allow that ruling on that argument. But the argument about whether or not she understood what she had been served with and so forth is clearly, if you have talked with her over the phone, then your testimony is an essential part of these proceedings. And as a result, I'm going to set it for a hearing, whether that, is advantageous to one or the other, or whether either one of you like it or not. I'm going to have to set another hearing. And the question becomes, what day are we going to set that hearing? And I'd like to do it this month while I'm here on my term of court. So I have, Ms. McKinney, are you there with us? Can you give me a question? Am I hearing the Jimmy Reeder PCR post-conviction relief hearing on the 21st? She may not be able to answer. So.
Yes.
That's still on? Okay.
Yes, sir.
Well, I have the 15th of July, which is already a Cheatham Chancery Day. On the 29th, Mr. Bonneberger, what did you say? You have something?
I have a contested divorce in Montgomery County.
And it is a go.
It is a go.
Looks like the 15th
15th is fine, Your Honor.
of July. All right, 15th of July, we'll resume this hearing on that time. And Ms. Tech, your client will need to obtain.
But no, I can't on the 15th of
You cannot?
July. No, Your Honor, I cannot.
Okay.
Does it not matter that this had been pending a year and she never filed anything?
Pardon?
That this case had been pending for a year and she never filed anything?
What about August the 1st?
That'll be fine. I can do it August the 1st.
You have what was the first day you got a judge here? Other than me.
August first, check was. Case here.
Uh,
Yeah. And then. That magistrate session.
How long is your case going to take on the 29th?
I could probably be here by 1:30, 2 o'clock, Your Honor.
Your Honor, July the 16th might open up if the trial defendant pleads on the 8th.
On which day?
July the 16th?
The 16th?
Yes.
Okay, that's the Wesley Sovine.
Yes, he's supposed to plea on the 8th.
What about the 16th of July?
That works fine for me, Your Honor.
All right. We're going to put you the 16th of July. That's based upon an expectation that the defendant in that trial that set that day is going to plead. Then we'll know that for sure on the 8th.
I'm sorry, Judge. I had planned to be away that week. That whole week of July. If we could do it in August sometime, I'm not trying to.
Well, we don't have a courtroom that I'm available. I can do it in Charlotte, Tennessee, on a different day. For example, that August 1st date, I can hear you in Charlotte, Tennessee, in my regular courtroom there. You're both agreeable to hearing it out.
I don't have a problem hearing it in Charlotte. I have a brief motion in the morning that should take about an hour and a half, and I can leave out of Montgomery County. It is a juvenile motion that I doubt the other side will agree to reschedule with me. But I should be done by 10:30 and can, as soon as it takes me to get to Charlotte.
What about the 22nd day of August?
22nd day of August, because I'm wide open, Your Honor, all day.
All right, we'll hear it 22nd day of August
Okay.
in courtroom 5 at the Justice Center in Charlotte, Tennessee.
All right, Your Honor. Thank you.
Thank you, Your Honor.
8:22. 9 o'clock. All right.
All right.
Case is adjourned until then. I'll just hold on to the file. Okay. You can come in on Zoom. We'll get you a camera downstairs, and if you get a computer yet downstairs that has an actual camera on it. And we're ready to move to the next. That is, Romkey versus Baker. Oh, yeah, I'm sorry. We did say that, didn't we? We're gonna, I'm sorry, I apologize to you all. This is, I had told the Woods versus Woods people I would take them up first thing on contested basis, and then I got sidetracked, so we'll take them up. All right, this is another Rule 60 motion for relief from a final order.
Ms. Wood, we'll just have a seat up here today. Your Honor, I've been retained by Ms. Wood to represent her. If the court looks at the file that,
I've got witness on call, so it's anyone who's going to testify other than the parties must go outside of the courtroom and remain outside of the courtroom until you yourself are called to testify. You're not to discuss the testimony of any other witness with anyone prior to your testifying. All right, now you resume, Ms. Rogers.
Your Honor, we're about to ask the court to set aside the final decree due to lack of notice to Ms. Wood. At the time the motion to set for trial was filed back in September of 2021, it was set, and at that time, the notice was sent to Jennifer No as attorney for Ms. Wood. Ms. No filed a motion to withdraw, which was not heard before the motion to set was heard. The motion to set was set on January the 3rd of 2022. The docket for the court shows that it was a no-show, that nobody showed up on that day. Then, in 1 year later, in March of 2023, there is an order to set this for a final hearing. And it reflects that it's for a July 23rd, July 6, 2023 date. I'm sorry. Yes, the order to set date for final here says that it's going to be set on July 6, 2023. But it reflects, even though it wasn't filed. Oh, I'm apologize. I did that. I said 1 year later. It wasn't. I apologize. It was filed by the court on March 6, 2023 for a court date signed by the court on February the 28th, 2023. But the court looks at the docket January 3rd, 2022. So it was 1 year later. I was correct when I spoke earlier. There was a no-show. Nobody showed up for that motion to set. So no one was here to get a date from the court, but an order was then filed by Mr. McNabb's office, and it says it was sent to Heather Wood. This was subsequent to her attorney withdrawing, but it was sent in care of her father, Craig Martin. We have him here today. He did live at that address at that time. He has subsequently moved to Florida, and he flew in yesterday to be here today. But he will state that he did not ever receive anything at that address for Miss Wood concerning this divorce. They also, in the final decree of divorce, state they mailed it to that address. Again, Miss Wood would testify, and her father will testify, that it was never received at that address. At the time the motion was filed to set it, she had counsel. Counsel obviously did not appear on that date either, so I can only assume that counsel did not get the motion. Counsel subsequently withdrew. Then subsequent to her withdrawal, there was the order entered 1 year after it was filed, or supposedly heard by the court, setting it for a final hearing, and Miss Wood was not given notice. So we're asking the court to grant our motion to set aside. I would further state my client will testify that during this time, yes, she knew that a divorce was pending, but that her and her husband were having meals together. She was seeing her child on a regular basis, that everything was going along. She did not know that the husband was pursuing this divorce or that anything was going on, and she was not represented by counsel. So based on the sole fact that an order was entered setting this case when no one appeared in court on the day of the motion, we're asking the court set aside that final decree.
Don't leave yet.
Sorry, Your Honor.
If I understand correctly, there was a motion to withdraw. There was a motion to set for trial and award of primary custody of the child that was set for January the 3rd of 2022.
Yes, Your Honor.
January the 3rd of 2022, there was a no-show. No one showed up.
Yes, Your Honor.
Then on February the 22nd, a motion to withdraw was filed by Jennifer No, who was representing the wife at that time, and it was set for hearing March 30th of 2022. And it shows that March 30th of 2022, that motion to withdraw was granted.
Yes, Your Honor.
And the order was entered on March 31st. Then no activity occurred until March the 6th of 2023. And on that day, it was an order, simply an order to set the final hearing. And that was entered by me on the 28th day of February. It was not filed until March the 6th. And there was no motion to set the case for trial. According to the court file, it just appeared that it appeared on an order was entered, but there was no motion to set the case for trial. And an order was just submitted and it was signed off on me. And I don't know whether it was signed off on the 28th day of February. There is no hearing shown in the court records of a hearing on February 28th. So apparently it may have just been an order to set the case for trial submitted to the clerk without anything else.
Correct, Your Honor.
All right. And then it was set for a hearing, and that was sent to Heather Michelle. According to this, there was a copy sent to Heather Michelle Woods, care of Craig Martin, on at the address shown on Shahan Road in Ashland City. And that was mailed out on the 17th day of February. So is it your position that on the 17th day of February, your client or thereafter, your client never received that?
She never received that. She'll testify that her first notice that this final decree had gone down was when she was served with the complaint for contempt by Child Support Services in October of 24. And up until that time, she'll testify that she was having dinner with her husband occasionally. She was visiting with her child, that they were just going on with their daily lives, and she did not know that he was pursuing this divorce.
All right.
Thank you.
McNabb, you want to respond to any of that?
Judge, this motion is, I assume it's a Rule 60 motion. 14 months after or 16 months after the entry of the final decree. Assuming Ms. Crabtree is alleging some sort of fraud, it has to be filed within a year, so that grounds out. The other issues, whether or not she was served, papers were sent to her address. Testimony from the son's going to reveal that they talked about this. She knew the divorce was over. The husband's going to testify that she knew the divorce was pending. She had from March of 28th, the motion relieving counsel was March 30, 2022. She knew at that time that the divorce was pending. She had a chance to get counsel. She didn't. I mean, the case law is replete on the issue of what she's trying to assert. It's just, she hadn't been denied due process, Judge. I mean, she got a copy of the order. I mean, if this were allowed, anybody who got a judgment could say, I didn't get a copy of it.
how did how did this case get set for trial? Did you just send an order in to set it? There was no motion in the file to set.
The motion was filed to set, I looked at the docket entry, Judge. I don't know. I don't remember
Let me
that.
assure you of one thing. I've read through the file. There is no motion to set the trial. There's no
Yes,
motion.
there is,
filed.
there's a motion set for trial.
Pardon?
Set it for, the motion was filed on the 28th of September to.
Yeah, there was a motion to
set
set the
to-
trial in September of 2021, but the order went down 2 years later. Or a year and a half at the latest. So,
Judge, assuming that's true. I don't know. I don't know what happened. I looked at the docket. I mean, again, one would assume that I'm trying to commit some sort of fraud.
I'm not accusing you of fraud, Mr. McNabb. What I'm saying is that normally there's a motion to set a case for trial. And that way both parties are notified that it's going to be presented to the court to assign a trial date. Then both parties can be present if they choose to. In this case, the motion to set was filed in September of 2021, and it was no show. There was no one showed up for it. Then a year and a half at least later, in March of 2023, a simple order to set the date for a final hearing was submitted, apparently mailed in, and it was put into the file that I have to sign orders. And so an order was signed setting it for a trial, but there was never a hearing on the motion to set the case for trial. And that concerns me. I'm not saying you did anything fraudulent. I'm just simply saying there should have been a motion to set filed in March of 2023 prior to the court assigning a trial date. It actually would have been February of 2023 because that's when the order was actually signed. It wasn't filed until March the 6th.
I don't know how a trial date would possibly be secured. I don't know, Judge. I can't answer that question. All I know is that the case was set for trial if she didn't know about it. If she didn't know about the trial date, it still doesn't make any difference. She got a copy of the final decree. And the final decree was final for 16 months before she took some action against it. So that's really the core of this question is from what she seeks a remedy is not from the motion to set or not to set or have a trial date. The remedy is from the final decree. The court heard the case, heard the divorce, signed the final decree. That's what she's seeking remedy from. And she's had a copy of that. It was mailed to her at the address that was provided not only to me, but to her lawyer, because the lawyer filed her motion to withdraw and sent it to the same address. No new address was ever given. I comply with the rules of procedure by sending her a copy of that. Testimony is going to be that she knew about it. She knew about the divorce. And that's the remedy she's seeking. Set aside the divorce. And I mean, it was heard by you. So we had a hearing.
All right, Ms. Myers, you want to put on your proof? I'll hear your proof.
William Craig Martin, Your Honor, he's my witness in the hall. There's an officer out there. I'll get him.
Come around here, sir. Step up. I need you to stand and raise your right hand and be placed under oath. Place our clerk, raise your right hand.
Yes, I do.
Have a seat, please. Be careful that chair moves.
Okay. I'm ready.
Please state your full name for the court.
William Craig Martin.
And you currently reside in Florida, correct?
I do, Vero
But-
Beach.
And you previously lived here in Tennessee, correct?
I did.
What was your address?
1365 Shahan Road, Ashland City, Tennessee.
And how do you know, my client, sorry, Miss Wood?
She's my daughter.
Did you know that her husband had filed a divorce from her?
No, I did not.
Have you ever at the address on Shahan Road received mail for her from Mr. McNabb's office?
I have not.
So are you aware of any documents that have been sent to her concerning a divorce?
No, ma'am.
No further questions, Your Honor.
Hold on.
Were you at any of the hearings in this case?
No.
Okay. You're aware that your daughter had a hearing earlier, right after the divorce was filed?
No, I was not.
Okay. So did you ever receive any correspondence from her lawyer at your address?
Not that I know of, no.
Okay, not that you know of.
Nothing that I had seen,
Okay.
or nothing that I had touched.
Did your daughter live with you at one point in time?
Yes.
Okay. When did she move?
I'm not sure when.
I'm sorry?
I'm not sure when she moved.
Okay. She ever received mail at your address?
Sometimes she did, yes.
She would go to the mailbox and get her mail and open it, so you wouldn't have any idea whether she got a letter or not.
Well, she probably wouldn't go to the mailbox very often, but I would just bring the mail in.
Okay.
And if it happened to be hers, I probably wouldn't pay any attention. I'm not gonna look at her mail.
There you go. So something could have come in, addressed to her that you didn't know who it was from and gave it to her.
I guess possibly.
All right. Okay. So you can't state under oath that she didn't receive any notification of a divorce hearing because you never did open any of her mail.
I did not.
Thank you.
Just to be clear, Mr. Wood. I'm sorry, just to be clear, Mr. Barton. After she moved from your residence, did she receive any mail from an attorney?
No, ma'am.
No further questions.
Hold on just a second. I have a question for you. What is your actual street address?
My current address is 424 Bimini K Circle, Vero Beach, Florida.
Back at the time that this was going on, what was the address on Shahan Road?
1365 Shahan Road, Ashland City, Tennessee, 37015.
And when did you relocate from that? When did you move?
I moved February 22nd of 2025.
All right. So in 2022 and 2023, you were living at that 1365.
Yes, sir, I was.
And if her prior attorney, Ms. Jennifer No, had filed a motion to withdraw, and she shows that she sent that to your daughter at 1365 Shahan Road, Ashland City, Tennessee, 371015, that would have been where she was living at that time. That would have been back in
yes.
February of 2022. I'm sorry, February 22nd of 2021. Was she living with you then?
I don't remember. I can't say that with it being 2025.
How was your mail received at that address? You have a
No,
mailbox?
mailbox. Yeah.
Okay. Out by the road or on your
It's
house?
out, yes, it's out by the road.
Did your
but-
daughter ever receive the mail and go check the
Very
mail?
seldom. Most of the time, my grandson usually went to the mailbox and got my mail.
All right, thank you. Now you can sit down.
I call Heather Wood, Your Honor. You could have a seat.
What if you raise your right hand, do you place under oath?
Yes. Please state your full name for the court.
Heather Michelle Wood.
Ms. Wood, you're not denying that you were made aware that you were served with a complaint for divorce, correct?
Yes, ma'am.
Okay, so you knew a divorce was pending.
Correct.
Okay, and at that, initially you had Miss Jennifer No representing you.
Yes.
Okay, and then Miss No filed a motion and withdrew from your case. Is that correct?
Yes.
And that was back in 2021, correct? Or I'm sorry, in 2022.
Yes.
Okay, at that time, where were you residing?
At my father's place on Shahan.
And you were aware that Miss No withdrew?
Yes.
Okay. Were you aware that they filed a motion to set it for a final hearing in
No, ma'am.
September 21?
No,
Did you go to a court date in the beginning of 2022 concerning the motion to withdraw?
no,
Did you go to the motion for your counsel to withdraw?
no,
After your counsel withdrew, did you receive any other documents?
no, ma'am.
When did you move from the residence?
I moved in 2024.
Okay, so in 2023, you were living in the residence.
Yes,
Did you receive any documents from Terrence McNabb's office?
no, ma'am.
Attorney, okay. And were you aware that this divorce had become final?
No, I was not.
Okay. Now, you were living at that residence. What was your relationship with your ex-husband and your child during that time?
Well, Levi came to my father's house every day after school. I picked him up on Monday afternoons as well as Friday afternoons from school at 2:45. He stayed most weekends with me and my dad at that residence. Matt and I talked occasionally when we had things to discuss about Levi. I did show at Levi's birthday party where him and his girlfriend at the time were there in 2023. That was around February 16th.
So y'all were going on your day-to-day life.
Yep.
And you were seeing your child on a regular basis.
Yes.
Okay. Did Mr. Wood ever say anything to you about the divorce being final?
No.
Did he ever say anything to you saying you owe me child support?
No, ma'am, he did not.
Okay. When was the first time you found out that this divorce had happened?
When I was served paperwork for contempt on child support on a Friday afternoon.
Okay, and you immediately retained me, correct?
Yes.
And we filed this motion.
Yes.
Okay. Now also, so why did you not pursue the divorce or do anything with the divorce?
I didn't have a lot of funds at the time. It was also during COVID, which everything was pretty much shut down for a period of time. He had filed the motion. You know, I was under the impression that we were going to get joint custody as well.
And what gave you that impression?
There was a temporary setting for a motion where I had Levi for 1 week and then he would have Levi for 1 week.
Okay. So that you thought that's what y'all were doing. You were
Yes.
working it out.
Yeah.
Okay. But again, at any time, did you know that this final decree had gone down?
Absolutely not.
Did you receive any documents from Terrence McNabb's office?
No, I did not.
No further questions.
Mr. McNabb, you may question the witness.
When did you move from your father's home?
2024,
2023, 2024?
2024, March of last year.
Okay. And so until that time, you were living there and receiving your mail there?
Yes,
Okay. And the address that he gave the judge is the address where you were living?
correct.
Okay. Now, you knew about Jennifer withdrawing from your case.
Yes,
You got a copy of the motion to withdraw from her, and you got a copy of the order that she got from the court withdrawing from your case. You received those at the address where your dad lived and you lived.
I'm assuming so. I don't recall specifically receiving them though.
Well, you do recall getting an order from her withdrawing from your case.
Not exactly.
I'm sorry?
Not exactly, no. I don't remember
Well,
receiving the
record was
paperwork.
shipped. I'm sorry, I didn't mean to interrupt you.
I'm sorry, go ahead.
You may have gotten it.
I could have gotten it, yes.
Okay. And well, you didn't communicate with her for a long time after a certain day, so you knew she wouldn't own your case,
Yes, sir.
right? And you knew the divorce between you and your husband was continuing to be pending because it'd never been dismissed.
Correct.
All right. And when this first started, it looks like, and I've got the date on September the 28th or 21st, 28th, 2021, your husband filed a motion to set for a final hearing and award custody of his son to him. And we had a lengthy hearing. Is that not true?
Was I present?
You were here when we had a hearing because wasn't this issue about a next door neighbor, a lady, wouldn't it?
Oh, yes.
Jack, I think he's molding the two motions together because the court says no show, the date the motion is set for trial. It says no show, no, but there was no hearing on that day. He's asking about two different motions.
Identify the date of the motion, the hearing that you're.
Motion, I'm sorry, I didn't understand what you said, Judge.
She said that she's saying that the motion you're referring to was not on the day of the motion for the court to set the case for trial, that motion was filed.
That was the one the one that I filed on September the 28th, 2021. It was the very first thing I filed.
Your Honor, that motion was set on January the 3rd, 2022, and that's the one the court docket says did not happen.
Judge, there's a document in the file for motion to set and to set for custody. It's in the file. And that was filed on September 28th, 2021. Now.
All right, and
from that document.
What date was that set to be heard?
It was heard in front of Judge Mash, Judge.
Your Honor, it was set to be heard on January 3rd, 2022.
That's another.
One of you talk at a time. There's a motion to set for trial and for award of primary custodian of the party's minor child. That was filed with this court on September the 28th, 2021. That's what you're referring to. It was the motion expected to be heard on January the 3rd of 2022. And that was sent to Jennifer No by certificate of service. Then on February the 22nd of 2022, and that was to be heard on January the 3rd. The docket in this case shows that there was no show on January the 3rd of 2022.
The hearing he's speaking of was heard on October 3rd, 2019, and the court records reflect visitation with father every other week. That's what it was.
So
That was in 19.
I think that Ms. Myers is correct. The hearing you're referring to is not the hearing on the motion to set. It is a motion that was heard.
Well, there was a motion to set and to have for her. There was two issues, and this is a hearing where she appeared with Jennifer No.
Well,
we had a hearing in front of Judge Mash.
There's no dispute about the fact that there was a hearing and she appeared with her lawyer.
You remember that hearing?
Yes.
Okay. And the judge reserved certain issues until the final hearing.
I'm assuming yes.
Okay, all right. So you knew there would be a final hearing at some point in time after that first hearing?
Yes, correct.
Okay. All right. Now, you allege in your motion certain issues about the chronology of the issue. You recall filing a petition?
Yes.
Okay. And in that petition, you were aware that there was a parenting plan.
Correct.
So how did you know there was a parenting plan if you didn't know about the divorce?
Well, the parenting plan I thought was what was the joint custody at the previous hearing.
Well, paragraph 4 of your petition, it says wife was awarded no parenting time with the party's minor children or party's minor child. How did you know you weren't awarded any parenting time?
I didn't know at that time.
Well, it's in your sworn petition that you weren't awarded any parenting time. How did you know that when you signed this?
Stipulate that at the same time we filed a motion to set aside the final decree, we also filed a petition to modify the final decree if the court denies our motion. So we will agree that as of the date of filing the petition, she was aware of the final decree.
I believe it's a stipulation that she found out about the final decree, and contemporaneously with her motion to set aside that final decree, she filed a petition to modify.
So you in your petition said you seen the child just about every day.
For periods of time, yes.
I'm sorry?
Yes, for periods of time.
Okay. And he's here today. Your 16-year-old son's here.
Yes.
Okay. And isn't it true, or do you remember telling your son that you knew you were divorced?
No, I did not.
You're going to say that you never told him that you knew you were divorced.
That's correct. I did not.
So if he testifies to that, that's not true.
I was never made aware that our divorce was final.
But if your son takes the stand under oath and says, Mom told me about the divorce and she knew
Then
about
he
it,
would
you're
be
going
lying,
to say
sir.
that's a lie.
Yes.
Okay. Do you know when your ex-husband moved to his present address? You know when he did?
I'm not exactly sure, no.
Was he living close to where your dad lived until he moved?
Yes, next door.
Next door.
Yes.
Did your dad and your ex-husband have a relationship where they talked to each other?
Yes.
Okay. Did your ex-husband move from his address next door to your dad before you moved?
Yes.
So you moved in 2024, so it would be before that when they moved, or he moved. He and his son moved.
Yes.
His son is living with him,
Yes.
or your son is living with him. Is that correct?
Our son was living with him.
Your son, his son was living with him when he moved prior to 2024.
Yes.
And we know that the date that you remember. Prior to 2024, he moved.
Yes.
Okay, that's all. Thank you.
Just to be clear, Ms. Wood, the hearing in which they did the 50-50 parenting time was in 2019, correct?
Yes, that's correct.
And then secondly, did you have a conversation with your son about the divorce after you were served with the contempt and found out it was final?
Yes.
So you did at one point discuss that the divorce was done,
Yes.
but that was after you found out from child support.
Yes.
No further questions.
All right. Thank you, Mom. You want to sit down?
I have no further witnesses, sure.
We're going to take our morning recess. We'll be in recess for 15 minutes.
All right.
Okay, I think we're back. Ms. Myers, do you have any other proof?
No other proof, Your Honor.
Mr. McNabb, do you have any proof you wish to offer about this?
Oh, Mr. Wood, Your Honor.
Mr. Wood, come up, please. Raise your right hand, be placed under oath.
You need to speak up and sit up close to the microphone. State your name, please.
Stephen Matthew Wood.
And are you the former spouse of Miss Heather Wood?
Yes,
Now, you've heard her testimony here today that you and she has this great relationship and y'all were eating dinner, sharing time together regularly. Is that a true statement?
no,
You recall having the hearing here early on where you got temporary custody of your son?
yes.
Okay. And at that time, where did you live?
I live next door to her father.
Okay. And when did you cease living next door to her father?
I moved to Sango or the Clarksville area with our son.
When did you move?
2021?
She said you lived there till 2023.
No,
That's not true.
no,
Okay. So you moved from there and moved to Sango in 2021. Is that correct?
that's correct.
All right. Now, after that move, did she have a relationship with your son and visit with him?
She would call occasionally and talk to him, yes.
Okay. Now, at the time that this hearing first began, she had an attorney, Jennifer No, is that correct?
Yes, she did.
Okay. And you're aware that sometime later, Ms. No withdrew from representing her?
Yes,
Okay. Now, you recall getting the divorce, in this case, in July of 2023?
yes.
All right. After that, after the divorce was over, what was the frequency of the visits that your wife or ex-wife had with the son?
Your Honor, I object to the relevancy. It's just on the motion to set aside.
Relevance, Mr. McNabb?
Judge, I'm trying to establish how often she talked with the son, but I'll go it another way. Did she
Overrule the
visit?
objection. I think it's relevant on the issue of her knowledge of the divorce decree and what the parenting plan provisions were.
Did your son talk with her on the phone quite a bit?
He does talk with her on the phone.
So she and he conversed quite a bit after the divorce.
Yeah,
Okay. Now, a minute ago, you were in the hallway and it was called to my attention from Ms. Crabtree that you were speaking to your son in the hall. Did you mention anything about what he should testify to?
absolutely not.
What did you tell him?
I told him it looks like we won't get out of here. They're going to ask you some questions.
Did you tell him what to say?
Absolutely not.
Okay. Is that all you said before you were,
That is all I said. He's
before you came
hungry.
back
He's
in?
ready to go.
Okay. All right. Now there's testimony from your ex-wife that she lived with your father-in-law, her dad until 2024. Does that sound about right?
She moved back in with him. She moved to somewhere else in between those years of 2021 to 2024.
Okay. So where was she living during the period of time after the divorce?
She has since
In
moved to
July,
Clarksville.
was she still living with her dad?
Yes, she was.
Okay. And that
She
was
was
in
still living
July of
there.
2024.
She was there for about 6 months.
Okay. All right. I think that's all I have. Thank you.
Myers,
I wasn't gonna bring it up, but you did not, you were talking to your son and saying stuff about being questioned in court. And I stopped and got your attorney, correct?
No, you interrupted me talking to my son.
And said, can't talk to your son, got your attorney.
And you said, you can't talk to your son about the case. And I said, I wasn't. I can talk to my son though.
But you were talking about what was gonna be asked in court.
No, I did not.
Okay. Anyways, so
try.
you agree, you lived in the home with your father-in-law, correct, at the time of this divorce prior to your separation?
Me?
Correct.
No.
Did your wife live in the home with your father-in-law?
Yes.
Okay. You moved in next door with your girlfriend, correct?
For a short period of time until me and my son moved to Clarksville. I lived there for 3 years in Clarksville.
Okay.
21, 22, 23.
What school is your son zoned for?
He is in Cheatham County School.
And you live in Clarksville.
Right.
So you use the address that
We both decided so he could stay in that school.
Okay.
This is not because she wanted to keep him there.
But you use her address.
Absolutely.
For the school.
Absolutely.
But you stated to this court, she's not supposed, she doesn't even see him. It's what you stated.
It was for her father, had nothing to do with her.
For her father, what was for her father?
We used that address because it was his address. He was with both of us.
Your son was with both of you.
Her dad. Me and her dad.
Your son
He
went
was
back.
in and out of places.
Okay. So she lived with her father for a period of time, then she didn't live with her father for a period of time, then she did. But your son went back and forth to that address, correct?
My son rode the bus home every day, as he has for 8 years to
So
that address,
He was there every day. Correct.
to ride the bus.
Now, no further questions.
redirect, step down. Mr. McNabb, do you have any other witnesses?
Call the party son. He's right outside the door, Judge.
You call who?
Party son, what's his name, Brody?
Levi.
Levi.
You have Levi out in the hallway.
He's right outside the door, Judge.
How old is Levi?
16.
We not have a court officer to go get him, Judge.
No.
Right here. Raise your right hand and be placed under oath.
State your full name, please.
Matthew Levi Wood,
How old are you, Levi?
16.
You understand what it means to be under oath?
So,
Now, you remember when your mom and dad got divorced? Okay. And during the time of the, before the divorce, where did you live?
for the divorce, I live with my dad.
I'm sorry?
For the divorce, I live with my dad.
before the divorce?
I live with my dad. Before they were finally divorced.
Where is that?
1096 Fanny Nicholson Road.
Do you know where your mom lived, at the time of the divorce in July of 2024?
No, off the top of my head, no, sir, I don't.
Now, what, you and your mom talk a lot?
On the phone, yeah, quite a bit.
Okay. What about visitation?
She calls me not regularly, no.
Do you ever recall her mentioning to you about her and your dad getting a divorce?
I do recall her mentioning something about it. I'm not quite sure what it was word for word. It had to do with some time between the time we lived at the new house. So right now, between September, I think it was.
When she talked to you about that, was she like surprised, upset? Did she mention anything about not knowing about it?
No, she just seemed calm.
Okay. She didn't act like it was a surprise.
No, it's just a normal conversation.
Do you remember where that conversation, did she mention to this conversation more than once or just once?
Just the one time that I recall.
You remember where it was?
It was in her car. I think we went to go eat that day.
You know where you were going or coming from?
No, sir, I don't.
But you recall it happening?
Yes, sir.
Now, did your dad have any influence on your testimony today? Tell you what to say?
No, sir.
When you were in the hallway, did he ask you to say anything other than the truth?
No, sir.
Okay. That's all.
Just to be clear, did she talk to you about that they were getting a divorce, or did she talk to you about it being final?
She mentioned that don't quote me, it's not word for word, but it sounded something like, you know, me and your dad are divorced, right? It had something to do with along those lines.
Okay, and was that while you've lived in Clarksville?
I haven't lived in Clarksville.
Where do you live now?
Coopertown, I think it is.
Coopertown, I apologize. So, well, you live outside Cheatham County or the Sycamore School District, correct? Okay, and so was it after July 2023? Do you know when it was?
Like the month?
A year?
I would say not really, no.
Okay, no further questions.
Thank you, sir. You may step down. You can have a seat back out in the hallway. Mr. McNabb, I'm gonna call your next witness.
Go to the witnesses, Judge.
Any rebuttal?
No, Your Honor.
I'll hear you in argument.
Your Honor, the fact is that in a divorce, we have things that we do. When we're gonna set a final hearing and another person is told about a final hearing, but through a motion. She was told through her previous counsel that they were doing a motion to set in January of 2020. I'm sorry, all these numbers are going through my head now. So it was set to be heard on January the 3rd, 2022. They filed the motion in September, set it for January 3rd, 2022, and did not show up. That motion was sent to her previous counsel and it was never set. Then her attorney comes before the court a month and a half later on February the 22nd and sets a motion to withdraw. It's heard on March 30th. It is granted. We still have no final hearing set. A year later, more than a year later, there is an order entered that is alleged to have been mailed to her address at her father's house. Mr. Wood testifies that Miss Wood lived there at times and did not live there at times and went back and forth. But Miss Wood and her father both testified they never received a copy of that order. We have the fact they did not show up for court. This matter was not properly set for a final hearing. She did not know about a final hearing and did not come before this court. Whether she, we have the fact he moved in next door in his girlfriend's house. He was living right there. I don't know where the mail went. I'm sure he was receiving mail for from his attorney also. Whose mailbox it went in, I do not know. But my client testified she did not receive it. They did not come to court to set this final hearing, and the final hearing should be set aside.
McNabb?
It's undisputed that she was living there at the time she got the letter from Jennifer No. She was living there at the time the final decree was mailed in 2024. She was living there. Rule 60 is clear, just so that I won't misstate what it says. I'll read it. You probably got it in front of you, but in any event, on motion and upon such terms as are just, the court may relieve a party of the party's legal representation or legal representative from a final judgment, order, or proceeding for the following reasons. Number one, mistake, inadvertence, surprise, or excusable neglect. Number two, fraud, whether heretofore demonstrated intrinsic or extrinsic misrepresentation or other misconduct of adverse party. Those two grounds have to be brought within a year. Within a year. So assuming that's what they're saying, that I did something fraudulent or there's some misleading or something, irrespective of that, it had to be brought within a year, was not. The other ground is the judgment is void. There's no allegation or proof that that's the case in this case. The judgment's been satisfied. The catch-all phrase is for any other reason the court seems just. But in all respects, it's got to be done within a reasonable time. 14 months is not a reasonable time. Number two, there's no proof she didn't get the documents that were mailed where she lived. That's all that's required by the rules of procedure. So
there's no proof that she didn't get them.
there's no proof that she didn't get them.
There's no proof that she did. She testified and her father testified that they did not receive those.
Judge, the rules of procedure say service is complete upon mailing.
It's a presumption.
So that's all.
All right. First, let me address the issues that Mr. McNabb has raised. Rule 60 does provide that there are certain limited methods by which a final order can be set aside or a party can obtain relief from an operation of the judgment. Number one, judgments by default are not generally recognized or not generally favored by the court, especially in a court of equity such as this. This is an interesting case because it is a default judgment that was entered, but it's entered as a default judgment despite the fact that there had been an attorney representing Ms. Woods in the past who have withdrawn and so forth. Rule 60 does provide that must, for certain things, certain bases, rule, I think the number one and number two, which had to do with mistaken, inadvertence, or excusable neglect was the first one. And the second one was by fraud, whether intrinsic or extrinsic. Those two reasons have to be brought within 1 year. The fifth provision under that is for any other reason that would justify or justification that the court may find in particular in this case. So that one does not require a 1 year filing if you're proceeding under that. And what that says, for any other reason justifying relief from the operation of the judgment. This the motion shall be made within a reasonable time and for reasons 1 and 2, not more than 1 year after the judgment or proceeding entered thereon. It is this court's opinion that the application of Rule 60.02 subsection 5, any other reason justifying relief from the operation of the judgment, would have to be the only basis by which Ms. Woods could obtain relief. So then we move to, is there a grounds for relief? The testimony has been that she was not aware, her counsel having been discharged, that she was not aware of the fact that there was a final hearing set. It causes this court concern as to how this case became set for final hearing because, as the record reflects in the rule docket, there was a hearing, a motion that was filed to set the final hearing in this case. And it was set for January the 3rd of 2022. That motion was filed in September of 2021. In January of 3rd of 2022, no one appeared. There was no show. And as a result, that motion to set was not heard. And by operation, I think, was basically stricken because of the fact that it was not heard. Then an order was submitted to the court, to me, for my signature, setting a date for a final hearing. The file does not reflect that any additional motion to set was filed. It was simply an order that was entered after it was filed, sent to the court. Unfortunately, there are many times when we have the orders that are sent in that we don't always know, if there's not both lawyers, we don't always know how accurate those orders are. Rule 40 of the rules of the Tennessee Rules of Civil Procedure provides for the setting of cases for trial. Rule 40 states the following: the court shall provide by rule for the setting of cases for trial, A, without the request of the parties, but upon notice to the parties, or B, upon request of a party and notice to the other parties. Precedence shall be given to actions entitled thereto by any statute of the state of Tennessee. And essentially, the comments in that rule make reference to the fact that the provisions for are directory, but the committee felt that circumstances as to the setting of local trial dockets are so varied that this matter had to be left in the trial judges in each circuit or division for their discretion. We adopted the local rules of practice for the 23rd Judicial District, and under Rule 3 of the local rules of practice for the 23rd Judicial District, Rule 3.01 states the following: the setting of non-jury trials, except for chancery days which may be set by the clerk and master, cases shall be set for bench trial in one of the following ways: A, by agreement of counsel; B, by motion; or C, by the court with subsequent notice to counsel. In this case, the court finds that none of those rules, none of those methods were adhered to in this particular case, that there was no motion filed after that September 2021 motion that was filed and never heard, that there would have been, to have set properly this case for trial, it should have been a new motion to set, filed, and served upon the respondent in the case. Ms. Wood and her father both testified they did not receive the notice of the hearing or even a copy of the final decree of divorce. And as a result of that, this court is of the opinion that, being a court of equity, that and under the rules, Rule 60.02, subsection 5, that just cause exists to grant the motion for relief under Rule 60. So therefore, the motion for relief under Rule 60 is granted, and the final decree of divorce and parenting plan adopted under that order is hereby set aside. The matter is returned to the active docket of the court. In other words, you will draft an order reflecting the court's findings. So. All right, we're ready then to move back to William Romkey versus Sarah Baker. Romkey versus Davis. Romkey versus all right. And this is a motion for an amended motion for relief from sanctions and default judgment.
Yes, Your Honor, and on Rule 60, I didn't realize I was going to get such the education on Rule 60 this morning for all of the motions.
All right, I'm ready to hear you.
Thank you, Your Honor, and we filed a fairly lengthy memorandum with exhibits on this. Today's motion is mostly based in law, in legal argument, and it's mostly based on a case called Asani that goes through the analysis in Adams versus Illinois Central Railroad and the analysis in Mercer versus Vanderbilt, which outlines what is required of a court to strike a pleading based on a discovery sanction. It also goes over the required findings of the court to issue an order for discovering sanction. And we're using Rule 60 today to really address those guidelines and ask for relief from that order and the subsequent judgment. The order we're specifically asking about today is a May 2nd, 2024 order that struck Mr. Romke's pleadings. The order itself states no basis as to why or if it was a discovery sanction. Mr. Romke wasn't present at that hearing, and the record would indicate on 2/23 that motion for sanctions was filed and served on his former counsel. His former counsel withdrew on 3/7, and then that motion was heard on 4/15. This would all be in 2024. Exhibit 3 to my motion was kind of an interesting one. I actually pulled the motion and the order from Asani from the trial court to compare those to the motion and the order that we had before us in this case. And the Asani motion actually has much more egregious allegations. It accuses Mr. Asani of delaying his case by hiring 5 different attorneys. It accuses him of failing to comply with drug screens. It accuses him of responding to a discovery, not responding to a discovery in violation of an order. It accuses him of violating restraining order and not appearing at its companion criminal case, and kind of goes over this allegation that Mr. Asani was harassing renters at a marital rental property. In contrast, Ms. Baker's motion only alleges one thing. It alleges Mr. Romke missed a Zoom deposition on January 10th of 2024. And what's curious about that motion is it asks for relief under Rule 37.04, which requires a deponent be served with proper notice. And if you review the record, you'll notice there was no notice of deposition or agreed order setting that January 10th, 2024 deposition. Now, in full candor on the record, there was an agreed order setting a deposition on November 30th. And the subsequent pleadings indicate that everyone appeared at his former attorney's office, but a court reporter wasn't secured, and the deposition was rescheduled somehow informally for January 10th of 2024. However, that still doesn't really waive those 37.02 requirements that you have to, provide formal notice of a deposition. It also cites Rule 37.02, which is sanctions for the violation of the discovery order. But as I was saying, there's no discovery order putting a deposition on January 10th. So there's not a orderly violation underlying. Now, my first point then is Rule 37.04 and 37.02 weren't really applicable to that motion. There wasn't grounds to issue that sanction on that date. But I wanted to go ahead and be fair and make a second point that even if the court found that was appropriate, it still wouldn't matter. Both kind of roads on this kind of lead to Rule 60.
Of course, I'm not the one who found that sanction and imposed. That was Judge Wallace, I think, that imposed the sanction against, if I recall correctly.
I believe you're correct, Your Honor.
It was Judge Wallace who found that failure to appear for the deposition would result in a sanction of dismissing his answer.
And that is correct from my memory, Your Honor. And I'm sure you know your own signature, so sure it's correct. So kind of on that second point, when we start talking about the Asani case is, in that one, the trial court was reprimanded for failing to state a reason why the pleadings were stricken, and notes that the court must consider whether the sanction is proportional to the failures at issue. And it outlines that 4-part test in Mercer versus Vanderbilt that has to be gone through, that analysis that has to be gone through before that discovery sanction, which wasn't done at the hearing and wasn't outlined in the underlying motion for sanctions. It goes on to note that the test is subject to heightened scrutiny when the dismissal is based on a discovery sanction. And the Mayford order and the order under Asani are both under Exhibit 3. They're both very bare bones. They don't make any findings as to why the sanction was issued. And in the Asani case, the Court of Appeals goes on to say the bare bone nature of these sanction orders thwarts the court's ability to have any meaningful analysis because we're unable to discern what legal standard reasoning or even violation underpin the sanctioning order on appeal. Thus, we vacate and remand. Now, that kind of gets me to the underpinnings of the kind of the legal concerns when I'm seeing this. I kind of want to move back over into some of the Rule 60 kind of language and how this sort of fits in that. The first argument I sort of make is under Rule 60.03 under subsection 3, and that's the voidability or a void order. A void order. The order makes no reference to a legal standard, legal reasoning, or violation of law. I further argue that the underlying motion was incorrect and it cited 3702 and 3704, but there's no formal notice or no order to trigger that sort of relief. When I looked at the law and I cited this on there as to what a void order was, it really says that there's a fundamental infirmity, and I feel that a lack of citation to the standard, a citation to a standard that's not applicable, and an order without findings would be a fundamental infirmity. I also cite a case called Hollerman in there, which states if an order is void, its invalidity is disclosed by the face of that judgment or in the record of the case in which the judgment was rendered. And here we have nothing on the record that really creates any of the necessary findings or relief to grant that order. My second part of this is under 60.021, which is, as your honors are aware, a mistake, inadvertence, surprise, and excusable neglect. And when I was looking at how to address that, we cite a case called Henry, which Henry isn't necessarily the clearest in this instance. It asks if the default was willful as its first element. And the thing that's kind of unique about that is you can say the default obviously isn't willful because Mr. Ronke really showed up to the default hearing. And so we get into this sort of question of form or substance, right? And one of the things that's on the outline is once the sanctioning order, well, like the default order is kind of like the bridge to get the parties to what they need to do, but the sanctioning order is kind of like the legs holding up the bridge. So once you knock out the sanctioning order, de facto, the default order kind of falls in on itself. They all kind of get set down, kind of like Russian dolls, or they all kind of get set aside.
In other words, the basis for the court refusing to allow Mr. Romke to testify or be heard at the final hearing in this case was based upon the fact that the prior judge had imposed the sanction of not only finding him in violation of the discovery rules, but also struck his answer, and therefore he more or less was not before the court.
Yes.
And if that sanction was inappropriate under the case law that you've cited, then it was inappropriate for the court to deny Mr. Romke the opportunity to be heard at the final hearing.
Completely, and it's referenced that he showed up and he, of course, he wasn't allowed to testify because this wasn't before the court, and that's, of course, appropriate when a sanction has been issued. But when we just talk about that pure language of Henry, you could say the default isn't willful, but that was also why I kind of want to address maybe Henry doesn't apply. That seems to be the leading case. When you look at these cases, they use judgment and order very interchangeably in all of the things I read. So I want to kind of go ahead and address that Henry analysis as well, because it can very easily go back and forth. If Henry doesn't apply, I think this is a clear one where you can just argue that, a misstatement of law, a misstatement of fact, language of orders itself is, obviously excusable neglect or mistake. Unfortunately, the Asani case kind of puts the court in the role of a goalie rather than an umpire with it. So, I think a mistake of law is wholly something the court can set everything aside for. However, if Henry really applies, you can explain that once you set aside the sanction order, actually, I would remember that part. Not bad. It talks about in the sanctioning order, what would be the willful conduct, and the language it used was flagrant and unexplained. I just procedurally don't know how you could find to be flagrant and unexplained that Apologies, Your Honor. Well, the first issue is that there's no finding of what the conduct is. So that kind of makes it a problem of saying any of the conduct was flagrant and unexplained, right? Because there's not a specific finding as to why the sanctioning order was issued. I think opposing counsel will try to say Mr. Romke missed the deposition and that's flagrant and unexplained, but that's not the allegation in the, the flagrant and unexplained language isn't used and there's not a finding of that. It's also hard for me to think that you could ever have not showing up to a deposition being flagrant and unexplained when it wasn't set by a notice of deposition and it wasn't set by a court order, when it's set by informal agreement. And as the Honor knows, in a lot of common practice, sometimes we have cases where we can just get on the phone with another lawyer and we can schedule everything without a court order. Sometimes we take that procedural step of just coordinating and filing our notices to make sure, we have these sort of backbones with things, and it's entirely case by case and, attorney by attorney and even client by client. So there's no harm or foul with that, but there wasn't that protection in this case for Ms. Baker. So while some of this, could be poor practice or inconvenient, it's not illegal and it's not a violation of the law, setting a deposition just kind of orally or through email or something like that. However, the statute cited doesn't really give this bite of the apple to anything. It wants there to be this formal notice on the first caveat. The second factor under Henry is there a merit-based defense? I think that one's pretty easy. This is a child custody modification. There was complaint, answer and counter, amended complaint, amended answer and counter filed. It's a material change of circumstance denial and a counter petition for custody. So all child custody cases are so uniquely fact-driven. I think it's pretty clear that there are defenses there. And the third factor is would it prejudice the other party? And once again, this is under Henry if you find it applies. And I don't know how it could, there's two kind of levels with that. One is when you're looking at what's defined as prejudice, it's about your ability to still conduct discovery and to have a hearing on the merits, which is obviously still completely available. That's what we're asking for. But the other thing about it is, I don't know how you can find someone as prejudiced when they haven't done a notice of deposition. They filed a motion that cites two areas of law that don't apply. They haven't addressed the Mercer test. And I don't know how, she could be prejudiced when she hasn't used any of these legal tools that are required in this instance to kind of put a case like this to bed. Finally, I'm going to kind of address that last factor, factor number 5 of Rule 60. We talked about anything else that, the court didn't really look at in this. And before I filed all of this, I kind of looked at, if I appealed it, what does that look like? Would I actually be able to do anything? And when I looked at it, the standard is an abuse of discretion standard. Okay, what does that mean? One of the definitions of an abuse of discretion is applying the incorrect standards of law, which I think we have on a couple of levels here. So the remedy in Asani was a remand where they end up coming back to the trial court to do these things. So respectfully, I hope the court considers that factor because we have a child. I don't believe my client's seen this child since the day of the default hearing. Tying this up at the level of the Court of Appeals for something that would, clearly have incorrect statements of law in it, really probably would just delay us from coming back to this court for 4 to 8 months and doing what I'm asking for now. So respectfully, Your Honor, I'll tend to the podium to my opposing counsel.
I want to point out there's a lot of talk about how these depositions are set. Well, I'll point out that in the record on the date of October 13th, 2023, a notice of deposition was given to Mr. Romke. I said that in my motion as well, that he was noticed to a deposition sent to his attorney who was of record at the time. And on that day, no one showed up. So we entered an agreed order to reset the depositions. We set both parties' depositions. There's an agreed order in the file that says agreed order to set depositions. That's the day in November, shortly after I had originally set them for depositions. That's the day that we showed up here. I drove all the way from Murfreesboro and I found out that Miss Crabtree, Miss Myers had not procured a court report. So we had to reset those. So then at that point, we did reset them by agreement to sometime in January, I believe. And that's when Mr. Ronke did not appear, despite his attorney being on Zoom. We set him by Zoom so we didn't travel again. And we set him on Zoom and Mr. Ronke didn't appear. We set for an hour waiting on him. His attorney could not contact him. And then there was some mention, which I'd submit there's no proof that's ever been presented to this court, whether Mr. Ronke was here or not, as to why he didn't attend that deposition when it was agreed upon. So notice, agreed order, and then we set the depositions and he doesn't appear. And then, Your Honor, what we have after that is I file a motion for sanctions. He doesn't appear at that. I file a motion for default. He's set it in June. He doesn't appear at that. And then the court, not Your Honor, it was a different judge. The court at that time says to me, well, let's give him one more shot. So I set it off into August, sent him to him again. Mr. Ronke had multiple occasions to come to this court and say, Judge, I want to do something. The court even gave him 2 more months to file an answer or respond in some form or fashion. And he didn't decide to show up until August. So he doesn't sit here and complain like the other case Your Honor just heard that I didn't get something in the mail. He doesn't say that. He doesn't even submit an affidavit, which I think I submit Rule 60.02 when it comes to excusable neglect requires the court. It says in the case law that to meet the burden under 60.021, to offer proof of the basis from which relief is sought, to meet this burden, the movement must set forth in a motion or petition and supporting affidavits, facts explaining why the movement was justified in failing to avoid mistake, inadvertent surprise, or neglect. There's been nothing submitted to this court at all. So what it rests upon is this argument that there was some legal, I guess, infirmity to the sanctioning order that was entered that, again, several times after, Mr. Ronke never comes to court. He never says he didn't get those things. He just says, well, now I want a second bite at the apple. They didn't appeal this case. They didn't file a Rule 59 motion. They did nothing. Opposing counsel, I believe, even filed some type of, I would submit it, it's not a motion, but akin to just a notice intending to file a motion that he did shortly after the default judgment came down. So that was in September of 24. There was a motion for relief, but it doesn't state anything. It's not actually a motion. And that was filed in September of 24. And then they wait until April to file this Rule 55 motion. They didn't appeal that. And now they're out of time to appeal. And the only hope they have is for Your Honor to go back and say, well, a different judge made some error at that time, even though the record's clear. And there's no contesting that he didn't show up for these depositions and that I tried to get him to come to a deposition 3 different times. And then he just blew off coming to court on several occasions too. Clearly, he had no intention to actually engage himself in this case. Now he decides he wants to, and he says, court, I'm going to take the most limited avenue I possibly can. I didn't appeal, didn't file Rule 59, didn't do anything like that. I'm going to take the most limited avenue, which is a Rule 55 or Rule 60 motion, to get this court to set it aside. Yeah, it is beyond me that that's the avenue that they've chosen to take at this time, Judge. But nonetheless, as to the actual motions, I will submit to Your Honor that Rule 60.02 only gives this court the ability to set aside a final judgment. So the court has to decide whether or not this motion, because I submit it doesn't actually pertain to the final judgment except for their arguments under 60.021 and 60.023. The first half of their motion pertains to setting aside an order that the court entered prior to, which is not a final judgment. That order could have been appealed as part of the case, and their arguments potentially, I'm not saying they would have, but maybe they would have won in the Court of Appeals. But the Court of Appeals is not this court. This court's limited to the situations under Rule 60.02 that it can set aside a final judgment, and that's all. So as to 60.02, I'd submit to the court, while I think opposing counsel is trying to open the door to all of these avenues for 60.02 relief, I submit that very clearly and succinctly, they have only stated 2, 60.021 and 60.023. Under 60.021, there's mistake, inadvertent, surprise, neglect. 60.023, the judgment's void. I'll address the judgment being void first because I think it's the easiest to dispel. Under 60.023, for a judgment to be void, it has to be without jurisdiction over the subjects or wholly outside of the pleadings. Clearly, it's not outside the pleadings. There was an order that struck his answer. There was a motion for default, motion for default to reset, and we come to court. Everything was done appropriately, we didn't have the issues your court dealt with in previous cases of not sending notices, not filing motions. There's none of that. Everything was done within the pleadings, and clearly this court had jurisdiction over the parties. The cases that I cited in paragraph 18 of my response say a judgment's not void because it may or may not have been erroneous. And a judgment's not void because a party is dissatisfied with the result or chose not to participate in the proceedings. Nor is a judgment void because the party claims it's unjust. A judgment is void if the court lacked jurisdiction over the subject matter or the parties, or if it was wholly outside the pleadings. There's no allegations of any of those things to this court. So therefore, we can dispel 60.023 very quickly. Under 60.021, as I've stated, the movement must set forth an motion or petition and supporting affidavits, facts explaining why he was justified in his mistake, inadvertent surprise, and neglect. Importantly, the respondent has not submitted any proof, no affidavits explaining how he was justified in this. And it would appear that the only basis that they claim for his justification is that he had an attorney and that he was in the hospital or something of that nature. But Judge, I asked for this information back before I even filed my motion for sanctions. I put that in my motion for sanctions. And I said to Ms. Myers at that time, if that's the case, please give me something showing he was in the hospital. Because if he is, I'm not going to file a motion for sanctions. Never got any of that. Instead, his attorney withdrew. I think that's telling, Judge. And he hadn't submitted any medical records here today to show he's in the hospital. He hadn't submitted an affidavit swearing to that. His attorney just kind of parrots that same thing in his motion, and they still haven't proven that that was the situation. In fact, again, notice, agreed order, agreed between counsel to set deposition, doesn't appear in any of them. So I would submit, Judge, that throughout this case, Mr. Ronke has shown a intentional willfulness to not participate in the proceedings. Then after the judgment goes down, he decides that I'm not going to appeal it, and I'm not going to file a Rule 59 motion, which was told my time for appeal. Could have been very easy, Judge, to file a Rule 59 motion. And instead he waits until April, and now we're almost a year later after that order went down, and he's asking for this court to set it aside. And I would submit to the court that the way we practice cases, and Your Honor just talked about it, is we do notice. We file a motion and we give everybody notice. They've given me notice that they're traveling under 60.021 and 60.023. That's it. And I don't think that they have, under this motion and the proceedings to this point, that they haven't carried the burden on either one of those motions to be able to get to this point. But nonetheless, in going back to 37.02, clearly I did notice him to a deposition. Yes, we agreed several times to reset those. We did agreed orders, we did other things, but none of those depositions ever took place. And there's nothing to suggest that Mr. Ronke didn't come to court. He just failed to appear. So on that motion date where the sanctions went down, he had the opportunity to show up to court. He had the opportunity to be here and say to the court, well, no, that's what happened. I actually was in the hospital, or here's why I didn't come to the first deposition, or any of those things. And he didn't do that. And I don't think this court should reward him now with setting aside a judgment that he just simply didn't take this case seriously for months and over a year. And now he decides he wants to, and the court is asking the court to set it aside through the most narrow means possible. Ask the court to deny.
Your Honor, we actually filed a bare bones and skeletal Rule 60 motion before the default order is signed by the judge, about 3 days before it's approved. And in that skeletal motion, we do say we're filing this and filing an amended motion. That unfortunately we didn't file to April. Now, the fact an attorney would use my injuries against me, I think also needs to be on the record. 2 weeks after that, or the first week of October, I'm in a car wreck where I break 3 vertebrae and I get a concussion. First thing they tell you when you get a concussion, you just can't, you shouldn't make legal decisions, so I have to take some time off. December, I have a child. March, my former associate attorney's son dies. I got this in April. Regardless, rule says it needs to be in within a year. So we're within a year anyway from an this order. I would have liked to have got it in earlier, but between all of those things, I just had some problems my client had to suffer through. The second sort of issue is I have a question for the court about, I guess, which direction this is in, because when I'm addressing these cases and these fundamental kind of infirmities, with this one, and I'm hearing Mr. Lewis argue, I'm really hearing Mr. Lewis go back, look at the stuff he didn't put in his initial motions and now try to argue it without putting it in writing ahead of time. I really was addressing this from a procedural thing, but I have my client, prepared to testify today about what was going on back then. I was just finding the procedural background. And if that's something the court wants to deliberate on beyond the procedural merits, I'd be happy to call and go through everything with it. We prepared that and everything, but I didn't quite realize that we were going to kind of go down this sort of, well, here's what I meant to do in my sanctioning. Here's what I meant to argue. Here's what findings I meant to do. Additionally, I would like to add, there is a notice of deposition to notice it for November, but there's not a notice of deposition to notice it for January. And that's just what the record shows on this one. So respectfully, Honor, would you like me to call Mr. Romke and kind of hear about I guess, some of the merit-based sort of things about what had happened back in, I guess it was in October?
I submit that the rule doesn't provide for that opportunity. I know you already heard testimony in the previous case. I don't think the rule provides for that opportunity. I think it's I think it's a legal argument to be made and gives an opportunity to provide it through appropriate means.
Well, both of you have filed memorandums, and I think it's something I'm going to have to take under advisement to consider and read. This is my second day of my term here, so I haven't actually been able to read through all of the cases that have been cited, but I think that's the more important portion that I need to look at. It's generally a legal issue, and the significance of the ruling by Judge Wallace that struck his answer as a sanction, and whether the Ashani case and the Adams case that have been cited would indicate that that was an inappropriate punitive action in excess of what was appropriate at that time. And therefore, there's no question that I relied upon that order at the time that the final hearing came on to deny Mr. Rumke the opportunity to be heard at the final hearing. I mean, because his answer had been stricken, and with no answer being stricken, the default was granted. So it really boils down to whether or not the significance of those two cases and any of the ones that you have cited would have on the impact of the ruling of the validity of my actions on the final hearing. So I'm going to take the matter under advisement, and then if I feel like there needs to be a further hearing with any sort of evidentiary matters, I'll let you know. But right now, I think the most appropriate thing would be for me to read through everything in the case, and that may answer the question one way or the other. I'll take, go ahead.
Asani was exhibit 1 to our motion, so you have to hunt it
All
down.
right. All right, then I'll take it under advisement.
Thank you, Judge.
I'll try to get you an answer as quickly as I can.
John, I'd like to add one thing, please. I still can't feel this case.
Okay.
I still can't feel this case.
You still what?
He said I couldn't feel this case. I can feel this case.
Well, I'm not.
Judge,
That is not up to me. Thankfully, the Court of Appeals will be the one to make that decision as to whether or not they can or can't feel. All right. That concludes our docket, so we'll stand adjourned.